You're listening to the Law and Business Podcast, hosted by Anthony Verna. We tackle the difficult questions where business and the law intersect to help you run a smarter business and avoid costly mistakes. Brought to you by Verna Law PC, a full-service law firm focusing on patents, trademarks, copyrights, domain names, and advertising law. For more information, call 914-908-6757 or send an email to anthony@vernalaw.com for more information.
All right. Welcome back to the Law and Business Podcast, and welcome back, Jim Cushing. How you doing, sir?
How you doing, Anthony? Thanks for having me back.
Hey, well, I know it's been a while, but the podcast is, a little intermittent on my end. It's a little more intermittent than I would like. So thank you so much for being back. Recently, I had an appearance in federal court in the beautiful city of Binghamton, New York, where they're so used to intellectual property lawsuits, and to the point that the magistrate judge was asking me about a provision in the Lanham Act that is little used, and the look of shock and horror in his face was something I don't think I've ever seen before. But in this
it's never good when you're teaching the judge the law.
No, that's honestly true. But I think that happens a little more for me than for you, which led to this magistrate saying, okay, this is a trademark and copyright infringement case. It's something that that he was fully admitting that he was not used to, but that there are two magistrates in the Northern District of New York that have intellectual property expertise and experience, and wondering if the parties would want to have one of those magistrates hold a settlement conference. And in this particular case, my client was all for it because we're dealing with a pro se litigant, so a litigant who's representing himself.
Right.
And it's, as I'm sure you're aware, a pro se litigant can be a little on the extreme side.
Well, they go into it thinking this is going to be my day in court and I'm going to go all the way, and they don't really understand the process or where they've got a weakness.
Exactly. So I think this was a smart time that a judge is forcing us into settlement. And of course, since then, I think the litigant has realized that, yes, he's not going to be going all the way and he's not going to be really getting his day in court. And so he's actually sent me a couple different settlement options since then. So have there been times when a judge has forced you, someone who's in family law, into settlements that you think are good and help the case rather than dealing with litigation?
You know what? I think that as I said, I'm a family attorney, or you said I'm a family attorney mostly, and I think family is kind of unique in the legal field because it really, a lot of the times, the object of a family case is someone who's not even in court. Your son or your daughter or whomever, and obviously not in divorce, but in the custody or support context.
Sure.
So you're dealing with somebody who's not present, who's the object of the case. It's not just money, or like no offense to your practice, but like a copyright. It's a real human being whose life is going to be affected, and when it comes down to it, we're trying to do what's best for that person. And sometimes what's best for that person is not necessarily some legal one-upsmanships. It's just a practical consideration. And, when you have a decent judge, they look at this and they see the legal arguments from both sides, but they're also, if they're worth their salt, they see a kid involved or a couple of kids involved that whose lives will be affected. And the judge may think, you know what, I think we need to get this thing settled, because having warring parents for a number of indefinitely is not good for anybody. And so he gets involved, or she gets involved, and says, maybe we should sit down and figure this out. And they sort of make the procedures in a way that the trial procedure in a way that sort of fosters, I don't want to say compels, but fosters that kind of resolution over a trial, for example. And I can give you an example,
please,
if I could. I had a judge, I won't mention his name, he's retired now, unfortunately, but I had a judge for many years in Philadelphia Family Court who had a reputation for holding perpetual conferences.
What's a perpetual conference?
So I don't mean in conferences perpetually, I should say. Gotcha. So for example, he'll have the court will schedule a trial date for X day. The parties appear. The judge will say, you know what, I'd like to have everyone come into the chambers to have a conference about how the trial will go. And that's where he will sit down and say, what are you doing here? And why are you doing this? And just give me an idea of what you're going to argue. And so we would. And he'll say, I don't think this is worthy of a trial. I think you need to figure this out. So I'm gonna reschedule our trial for 60 days from now. I want you to address these problems and let me know how you did it. And then we'll come back and conference again. And even though we had trial dates, it was very difficult to get actually into trial, because he would say, well, we need to talk about this. You need to figure this out. Come back in 30 days or whatever it is. And, you know, you don't want to say to a judge, stonewall a judge and say, no, I'm not going to talk about that, because you don't want to be that guy. And I think it benefited the clients ultimately, even though they got frustrated, because they never really got in front of a judge to badmouth the other person, which is really his goal, right? He didn't want the two parents coming in and like attacking each other. And I think he was sort of forcing people to figure it out, which is what you need to do in custody ultimately.
And I think that's what makes family law unique, is the emotions that sadly come out of divorce, that sadly come out of custodial disputes, and I think it's up to a judge to truly keep those emotions in check.
Yeah, I mean, what I will say is, at least in the context of family, I always tell my clients this, that, you know, when your kids are 2 or 3 or 4 or 5 or young, whatever it is, the reality of it is you are setting the tone for mom and dad are setting the tone for themselves for not just the next custody order, but until this kid is 18 or an adult. I mean, I say to them, you know, if you're going to poison the well when your son or daughter's 5, how are you two going to go to his graduation when he's 18 and be in the same room together when he's married and all that sort of thing?
Right.
And you're burdening him. So it's better for people to sort of figure it out. You know, you're going to have to live with this person forever, even if they're in your same house. You know, they got to deal with this person forever. So I think I think the way the judge handles that is really critical.
One of the issues that I think that makes intellectual property unique, and I kind of hinted at this in the intro, is that I think a lot of judges, I think a lot of attorneys don't know what intellectual property is to begin with, and therefore when attorneys become federal judges, if they are prosecutors all the time and maybe not familiar with the civil side or whatever the case might be, they just aren't familiar with IP law in general sitting on the federal bench. And sometimes, yes, I have to educate, but family law judges tend to be family law experts, because this is all they see.
They do.
As the state, you know, regardless of all this, you know, I'm licensed New York, New Jersey. Family law is its own court there. And certainly in Pennsylvania, family law is in its own court as well.
Yeah, I mean, in the bigger jurisdictions, like I practice in Philadelphia mainly, in the bigger jurisdictions, there is a segregated family court, and that's what those judges do day in and day out. When you go into the more sparsely areas, like Center County, for example, Center County, Pennsylvania, which has 4 judges for everything, that's a little bit different.
Do you ever find yourself struggling with a judge in terms of education of a case, or in terms of how a judge would like you to settle?
Yeah, you know, I have found that in the smaller counties, and that would, by smaller, I mean places outside the Philadelphia 5-county metro area, you know, where the judges become more jacks of all trades than specific. They either treat a family case like a regular civil litigation case, which it's not, right? I mean, it's one thing if you blow a deadline in a civil litigation case, you might lose, right? But no one ever loses a custody case, right? Or a divorce case or whatever.
Sure.
You have to, or a support case. And so, I mean, they, in that way at least, right? So they treat it like that, and then that becomes very frustrating.
Well, and I would assume that there are different rules of procedure for a Pennsylvania family case, just like in New York and New Jersey.
There are, but then, or they treat it like there are no rules, you know, and that gets frustrating too. So, I mean, family law is sort of in between, as it were. I mean, I sometimes joke that family law sometimes devolves into, you know, whoever gets their shoulders on the mat first, but it's not. But it really shouldn't be that way, and the judges shouldn't foster that.
Um, I'm hoping, I would hope that judges don't foster that in any particular case. I recently had a case that was moved to California, the Central District of California, and the judge there immediately sent the case out to private mediation first. And I've always found that private mediation and intellectual property are not all that strong, because a lot of times private mediators tend to think of things like business business solutions, when neither party is really looking for a business solution, neither party is really looking to work together. But that really, to me, seems like the core of family law. Like, both parties have to work together.
Yeah. Do you find that that judge did that because he was out of his depth and he was sort of like, just get it off my docket and here, you just deal with this?
Yeah, I think so sometimes. Yeah, I think there's certainly, in my case, I've had judges who've said, I just don't understand this case. I would certainly hope a judge, federal judge in Los Angeles, would understand intellectual property. I mean, if there are three areas where intellectual property is going to be tried more than others, it's going to be Southern District of New York, Central District of California, and oddly enough, the Eastern District of Texas, where a whole bunch of patent cases get filed because there's like nothing else in that particular section of Texas. So they wind up with a rocket docket, as they call it. Yeah, but other than that, I have certainly seen a few judges who don't understand IP and they kind of just want it off, and they order the parties either to the magistrate settlement conference, or maybe the issue is very simple. I once had a judge here in the Southern District of New York who ordered the parties to mediation, to a settlement conference by a magistrate judge. And I can tell you that the plaintiff was so angry at that all the attorneys like threw their pens down right in front of the judge after that order came.
I guess, did the judge say anything about that?
Judge did not say anything about that, oddly enough. But basically, she called on me, and I stood up, and she goes, "Mr. Verna, you seem like a person who likes to settle cases." And of course, I'm like, "Well, Your Honor, that does tend to be our first calling as counsel on cases, I believe." And I had filed a motion to dismiss in the case, and she's like, "Well, I could give you two options. You could retract the motion to dismiss. I order this to a settlement conference, and if it doesn't work out, you can tell me why it didn't work out." And I said, "Okay, Your Honor, that's one option. What's the other?" And she said, "I could just freeze all the dates and send it to the settlement conference." I said, "I'll take option 2." And she said, "Sure." And yeah, and then I have a feeling she knew that probably the plaintiff wouldn't be happy with that. But frankly, at that particular case, it wasn't a matter of infringement or did my client infringe. It was, what really, to be honest with you, in that particular case, it was damages. My client had not sold a lot of versions of the product that had infringed, and it was a situation where I told my client a million times, pick up the phone and call me before you sell something new. We don't need to go through a formal trademark search for everything, but at least call and we could figure things out.
If that's general advice for any client, I think.
Oh yes, I know.
Call before the decision's made, so I don't have to undo your bad one.
Exactly, but in that particular case, the judge saw that we were, despite the fact that we filed a motion to dismiss, that the issues in that particular case were narrow, and that all it came down to was, was really a number, to be honest with you. And while the plaintiff was certainly not happy with the number that came from the settlement conference, my client was happy that it was really low for a federal trademark infringement lawsuit. It was really low. So litigating would have been a lot more than that. So sometimes I have to do that cost benefit analysis. I had another case that was pure counterfeiting, and we had to file against 3 or 4 different defendants. and I mean, effectively, they were wound up being represented by one lawyer. And that was another case where I was like, look, I'd be happy with the settlement conference because as far as I can tell, all it is money, right? If they're just basically giving up in the case, I'd be happy in front of a magistrate. Let's get a number and move on with our lives. So sometimes a lot of judges have been happy to say, okay, good, you understand the problem. Let's get you in front of a magistrate, get a number, get the case off the docket.
Yeah, I mean, like I said, with family, you're really dealing with really personal, emotional things, and sometimes people. Does it surprise you that people in that situation become unreasonable because they're very angry or annoyed or hurt or whatever? And let me just tell you a story. I had a judge in one of the counties here sort of do realpolitik when it comes to settling a case. Or he had me and the other attorney come in the back room into his chambers. And he said to his court reporter, stop taking notes. And by the way, if either of you say anything to anybody, this conversation never happened, and I'm going to see you again in another hearing, which is like a strong arm way of saying you're getting this done.
Right.
This is stupid. I don't know if I would have done it if I were him. I think it's a little bit. But the situation was, in Pennsylvania, we have a variety of ways of divorcing. One way is the traditional fault divorce, which is what most people, I think of, that my spouse committed adultery or beat me up or left or whatever.
Sure.
And that's very traditional. But in the last 40 years or so, no fault divorce has arisen. And with no fault, there's literally, you're not claiming anyone did anything wrong. You're just saying we don't want to be married anymore. And no one has to prove anything. And there's two ways in Pennsylvania of doing a no fault divorce. One is both the husband and the wife sign an affidavit saying they consent to the divorce.
Right.
Or the other way is if you've been separated maritally, not necessarily physically in your same house, but you've not functioned as a married couple for, at the time it was 2 years. Now it's 1. We've not been together as a married couple for 2 years, and they're based upon that length of time, we can say unilaterally, we're not really together anymore. Let's just get this over with. And of course, there's defenses to that. But the point is that I had a client who I inherited from another attorney who I think I was her third attorney, which is never a good sign. But and she insisted that she wanted to pursue a fault-based divorce, of which there are literally 5 in the Commonwealth of Pennsylvania per year, because no one does them because there's no financial benefit or anything. It's just an emotional one. But her attorney did alternative pleading, which is, for those who are not attorneys here, that means you do multiple counts in your complaint, and you try to do the one that works at the time. And he put in a date of separation, a 2-year separation count in there as a divorce. And she was adamant of getting that withdrawn, but there was already an answer filed. Procedurally, it was that you couldn't really withdraw it anymore because the other party was refusing, and she's collecting alimony, right? So they're like, well, you can't do this forever. So the judge basically called us in, and that's a short story of the procedures. The judge called us into his chambers, said, this is the way it's going to go down. And he goes, here's how it's going to go down. And I'm sort of mostly quoting, but it's mostly some of it paraphrased. He said, this presents to me a very interesting legal argument to me. So I'm going to need you to brief that, and that's going to be due in 30 days. And he said to the other attorney, and I need you to respond to that brief, I'll say 30 days after that. And I don't know how long it's going to take me to read these briefs and rule on it, because it's very unique, sarcastically speaking, very unique, very niche. So it's going to I don't know how long it's going to take me to review this and come up with a ruling. But once I do, I'm going to have to schedule a hearing for oral arguments. And basically what he was doing is pushing these briefings, all this sort of fake, semi-fake briefing schedules out to the point where the 2 years would elapse, and he would just enter an order for divorce because the 2 years have passed. So he was like artificially creating a litigation just to get this over with, so we don't have to litigate anything. Well, and my client wasn't happy with it, but the truth of the matter is what she was trying to pursue didn't really have any purpose besides emotional one. You know what I mean?
Yes, no, I understand. I understand completely. I mean, look, I've even in IP, I've been there. I once had a case where I filed a copyright infringement suit, and then the other side countered with defamation. And it's a claim that was so far out there that it didn't make any sense to me. Meanwhile, if you looked at the, included in my exhibits were, my client's original work and what was found from the defendant's website. And it was, even the typos were exactly the same.
Okay.
Same exact mistakes in it, not just the same thing. But, the emotions between these two competitors were so high that the other side filed a defamation lawsuit and didn't want to do anything in terms of trying to settle the case because of high emotions, especially when it's two competitors going after each other. So, just to analogize, I do see that as well. But in your particular case, I thought the judge kind of came up with a creative way of saying, "I'll drag my feet until no fault is triggered."
Yes.
And so if you guys don't want to work it out, we'll just drag it. I'll drag it out myself.
Yep, and then get past the 2-year threshold and just deal with it. Because one of the legal issues in that case was, and this is what made it interesting, is that, as I said, there's the option to consent to a divorce, and no fault divorce. And her prior counsel put in a count for consent divorce. And so, but she was refusing to consent to her own divorce, but she was insisting to do fault-based. And there is case law that states that if you can't collect spousal support against your spouse, your soon-to-be ex-spouse, while also refusing to consent to your own, you can't artificially extend your litigation to collect support, basically.
Right.
So the judge was like, "Well, I can dismiss the whole case." And then it will start again, and that would dismiss the underlying support case. Well, I didn't want that.
Right.
So,
right, because she's got to maintain her lifestyle.
Yeah.
Or at least that's the theory behind support.
Exactly, right. And so, so then the judge is like, "Well, here's what I'm going to do. I'm going to make this artificially long, and not in so many words, and just do it myself." And I thought, well, that's creative. I didn't like how he went and did it. I'm going to sort of like, there's a not to paint a little bow on it. There's a his chambers had a screen door out into the courtyard, which is in the middle of the courthouse, and he was sitting next to the screen door smoking a cigarette at the screen door while he was talking to us. So it's very much like a shakedown, in like a weird way. But here's what I'm going to do. And if you don't like it, no, you can't. You can't say anything because I want to see you again. Just remember that. I'm like, oh, Jesus.
Meanwhile, the judge that handled the copyright / defamation case that I was talking about was a former prosecutor, and it was fascinating to arrive in court a little early for hearings with her, and see the criminal cases that were going on before her, because she would cut through those like a hot knife through butter.
Right.
And when it came to like our intellectual property case, I had written more than one request about trying to get the parties together for a settlement conference, because I think sometimes a good magistrate can take a case, wrap it in a bow, and get the parties to, and crack the heads of the lawyers and get them to seriously talk about what the meat is and get the case done and over with and settled. And get past that emotion, because a lot of times even lawyers will inhibit the emotions of their clients. And I kind of thought that's what opposing counsel was doing at that time as well. And this judge, she just she kept, in my opinion, kind of flubbing over what the main issues of the case were. And she kept saying that the other side, claims that that none of it was original. And I'm like, I'm not talking about the concept of what the works are. I'm talking about the actual words. Like, if you read the complaint, it's the words. If you look at the exhibit, it's the words. It's the actual exact words from one party to the other. And
you say you're talking about the hot knife through butter. I mean, I think that is one of the advantages of like a place like Philadelphia. I mean, there's disadvantages, of course, because of the huge backlog. But,
sure.
But
where isn't there a backlog?
I mean, but in Philadelphia, custody trials are like a year after filing, right? So, and your kid's whole life is different in a year, right? So, I mean,
that's true.
It's bad, but I will say that the Philadelphia family court judges, there is nothing they haven't seen, and so they're not impressed with like all of this sort of, a factual or legal or emotional appeals that are clearly at variance with what they're seeing in front of them, right? They said, I've seen this before. This is how you're going to deal with this. And unlike, say, for example, a smaller county judge who they don't see family cases every single day. And so they do sort of get sucked into the emotionality of it all sometimes.
Do you find that now that you know your father, you've got 2 kids, do you find that your own angle on this has changed?
Well, actually, yeah, I do. I want to say one thing before I get to that is that you mentioned the emotionality of the attorney. I will say that as a family lawyer, your clients sort of expect you to join them in their angst, and sometimes it's hard to do that, and they don't really like that because it might be wrong. But
well, I do that. Look, I tell my client, I tell a lot of potential clients all the time, especially when they come to me and it's a trademark opposition proceeding, and I say, look, this is a lawsuit, and it's a lawsuit only for you to register a trademark. Have you like fallen in love with your trademark to the point that that you're going to fight, and your business is still a startup? And they kind of like think about that for a second. I go, because you've ruined, you have already violated my first rule, which is don't fall in love.
Right. I mean, I would say for me, I mean, I've been a parent for essentially 11 years now, and when you're in the parenting mode, making parenting decisions every day as a person, as a human being, attorneys are human beings, I think.
Really?
As far as I can tell, maybe some of us are, and so when you have parents come to you and they're stressing out over their kid, I can sort of offer what limited wisdom I have in saying in 11 years and say, listen, this is a choice, not a decision. There's 2 different things. This is your kid's not going to be forever condemned to a life of mediocrity because of X, because he didn't get to this premier preschool or whatever. And just bring it down a notch or whatever, and I can sort of help with that in what I think is why. I mean, maybe I'm making unwise decisions as a parent. I don't know, but I can at least say from personal experience, I can offer them advice myself. Now when the kids are older than me, they might say, "Well, you don't have teenagers yet," which might be valid too. I don't know.
Well, no, and hey, I can understand. I can understand that as well. So. When a judge kind of forces you into this settlement mode, I know that trying to wrap this up into a neat little bow is nigh impossible. But good, bad, indifferent. How do you react when a judge pushes you into the settlement mode rather than trying to take this case all the way to the end through a trial in family law?
That's a good question. I think that I think for most people, and they don't want to admit this at the time because they're very strong feelings about the other parent. But the reality of it is 90% of the time, and that's not a scientific number, but it's probably right, that both parents are just normal, fairly decent people, right? I mean, they're not getting along with one another.
Right.
And that's not I always tell my clients, the fact that you don't like him and the fact that he hates you is irrelevant to whether they can raise your son, your daughter, or whatever. And so I think 90% of the time, the fact is they don't want to admit is that mom or dad are going to have time exclusive of the other parent with their son or daughter. They just are. And you need to figure out how to make that happen. You're not going to reduce this guy to visitation. You're not going to reduce him to supervision. You're not going to reduce him to 2 dinners a week. He's going to have time with his kids. And I think judges, obviously going into a case, assume that. That's the general assumption that both parents should have time with their kids. And so it's really just getting your client to admit to themselves, or him or herself, you know what, there's nothing you can do about this. The judge is sending you a signal. There's nothing you can do about it. And I always tell them, do you want to be in control of your life and your schedule? Or do you want some person who doesn't know you and you're just one of 1,000 cases to control your time and your schedule? I think it's better for you to do it. And most of the time they sort of begrudgingly concede that it's probably not good for some guy, which is to say the judge, who doesn't know them, and there'll be just one case out of 1,000 to determine when and where they can see their kids. Maybe they should have some say in that and come to a resolution. You know what I mean?
No, I understand that completely. it's.
By the way, I'm focusing on custody because child support is kind of mathematical and more or less straightforward, and divorce, that's a whole other ball of wax. But it's you're separating from somebody, and so you're less inclined to be open to settlement in that regard. But even there, it's like the law is very much, with a couple of exceptions, it's you're going to get half your stuff, and he's going to get half your stuff. So why don't you just figure out what half he's going to get? You know what I mean? Rather than having some judge do it for you.
No, I understand exactly what you mean. And not that long ago, there was a case that went up to the appellate division in New York. You file in Supreme Court. I still don't know why that. Yeah, you file in Supreme Court, Court of Appeals, then appellate division, then Court of Appeals is Supreme Court everywhere else. So there's a case that went up to the Court of Appeals, and it's like, what are you guys doing, spending all of this money on legal fees when you could just figure a way to split that money and keep that money?
Well, the thing about family, too, with custody at least, and support, is that it's always modifiable.
By agreement, or do you mean by agreement or by judge?
Either one.
Right.
And so, for example, if I litigate a custody case and I have a trial today or whatever, and the judge enters a verdict, if a month from now this isn't working out, you just request a modification and you sort of work through that. So because there are people who take these appeals up to the Supreme Court, which is the real Supreme Court in Pennsylvania, and not the first level. And it's just, I always wonder, like, why are you doing this? I mean, you just file for modification again, and sort of figure it out and tell the judge, hey, we tried this, it didn't work. Here's why, and let's modify. And so I don't understand the need to appeal, but some people are very much about that.
I mean, I have a friend who's a paralegal, and once in a while his ex-wife will ask for modification. And she of course shows up with counsel, and he goes by himself because obviously he's got enough experience to handle this himself. And he basically says, well, Your Honor, she offered this, I offered that, she rejected it, we're here. And the judge always kind of gets angry that whenever they're in front of a judge for the modification, because there's he always makes sure to try to counter offer and try to get somewhere in between.
Well, and family court is very unique, I think, in that depending on the jurisdiction, but I think the national average, 75% of the people in family court are pro se.
Yes, I can imagine that.
It's approaching 90. And so the process is user-friendly because it's equity-based, right? It's not a legal court. It's an equitable court. I don't know if you can explain to your listeners what that means, but
well, I would say that when you're dealing with a court in equity or an equitable court, it's there to make division so that both parties are at least have some kind of equity or are equitable when leaving. Whereas with the legal court, it's we're finding for the plaintiff, and that means there are damages that the defendant owes, or the plaintiff was completely wrong, and no damages.
Yeah, I'm not saying I do make legal arguments, but a lot of it is equitable based, and sure. So individual pro se litigants can do that sometimes too, and so. And judges, therefore, and I think that it makes family court sound kind of unique, is that judges are sort of forced to try to work with people who just don't know the law very well, but they know what's fair. They have feelings of fairness, and the judges try to address that.
So to try to wrap a neat bow into this, when a client comes to you and you're talking about custody, you're talking about support, is the client going to be prepared for the judge to use his or her strong arm to get the parties to keep talking?
Well, in my approach is, and maybe this is just me, I assume it's okay. I tell people, listen, like I said a minute ago, there are always exceptions to the rule, obviously, but I say to most of my clients, listen, dad or mom, they're going to have custody of your kids, or this person is going to receive support from you, or you're going to have to split your property in this approximate proportion. So, that's the legal reality when you walk into the courtroom. So if you have anticipation of walking in saying, dad should never see his kid again, you're going to have to provide a really good reason, and you don't have that. So let's try to deal with reality. And the judge is not going to put up with that. So you might as well come to the courthouse with, a reasonable expectation of what your case is going to wind up with. Because it's not like civil court where if you can't settle, you go for the moon and you get whatever's before that. And in family court, it's, it is what it is. Your dad's going to see his kids, and you're going to have to give 50% of your stuff up. So it's up to you or this judge to do it. I'd rather it be me.
Understood. Jim, tell everybody how to find you.
Thanks, Anthony. You can find me at FayRivaCohen.com, which is F-A-Y-E, this is F as in Frank, A-Y-E-R-I-V as in Victor, A, Cohen, C-O-H-E-N, FayRivaCohen.com. I'm at 2047 Locust Street in Philadelphia, and you can reach me by telephone at 215-563-7776 or by email at jwc@FayRivaCohen.com.
Jim, thank you for this half hour of kibitzing, war stories, and comparing and contrasting.
Thanks, Anthony. I really appreciate it.
Hey, not a problem.
Can't wait to come back.
We'll do it again soon. We won't make it such a long break.
Great.
This has been the Law and Business Podcast. Visit vernalaw.com for more episodes. To contact Verna Law PC, send an email to anthony@vernalaw.com or call 914-358-6401.